Welcome to today's program, 2022 Trade Secrets and Non-Competes Year in Review. Copies of the slides, a link to the recording, and the CLE verification form will be emailed to you in the days following the webinar. During the program, a CLE code will be read aloud, and you will be required to include this code on the CLE form. Throughout the webinar, please feel free to type your questions into the chat box on your screen. Now I'd like to turn it over to Michael Wexler, Robert Milligan, and Joshua Salinas.
Welcome, everyone. Depending on where you are, it's good morning or good afternoon. You see in front of you the three good-looking folks putting on the presentation today, despite that you can't see us. Myself, Michael Wexler, Robert Milligan, my partner in Los Angeles, and Joshua Salinas, our colleague in Los Angeles as well. Next slide. We're going to go through with you the following items. FTC's proposed ban on non-competes, notable restrictive covenant cases during the last year, new and proposed state laws, changing restrictive covenant rules, some notable trade secret cases and developments, increased government activities in the non-compete trade secret space, and also computer fraud post Van Buren to get you up to speed on all these areas from 2022. We'll turn to the next slide. But for the recent events in the past couple of weeks, our presentation would have been very different. But as many of you may be aware, the FTC has proposed a new rule which would essentially get rid of non-competes. And so that's the hot topic we wanted to make sure we lead off with for anyone who is either not aware of it or wants a little more insight on this. Since it's been all over the news and in legal publications, newspapers, op-ed pieces. We even put on a seminar last week on this topic. If you care to go to our blog at tradesecretslaw.com, where you can access a recording of that. What would the proposed rule do? Well, the proposed rule in a nutshell would outlaw non-competes, plain and simple. Basically, any non-compete that would essentially limit the ability of someone to move from a current employer to a competitor, that non-compete would be impermissible under the proposed rule. The proposal from the FTC, it's extremely lengthy. The proposal is currently what we call the comment phase, and comments on the proposal are due March 20th, at least currently. They're due March 20th, 2023. Anyone who is against the proposal, in favor of the proposal, you can actually submit comments, and we'll talk a little bit more about that in the presentation here. In the next slide, when you talk about a non-compete, the way it's defined in the proposal is essentially an agreement between an employer and employee that prohibits the employee from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment. It does not apply to a restriction on an individual's during the term of employment. It doesn't prohibit that individual from having an agreement or a policy, a handbook, etc., that prohibits employment with a competitor while they are employed by someone. This strictly applies to post-termination employment agreements. Also, the definition that they're using also includes what are called de facto non-compete clauses, which essentially have the effect of prohibiting someone from working at a competitor. Some of the things that are mentioned in the proposed rule from the FTC include possibly a non-disclosure agreement that might serve as a de facto non-compete. It includes a payback provision for training that could be seen as a de facto non-compete. It could include some type of equity rescission clause that essentially would eventually be termed a de facto non-compete. But of course, there are numerous factual issues and determinations that would have to be made which is potentially one of the issues with the rule, that a lot of real life practical situations are really not explored in the proposed rule and the effects that the proposed rule would have in these situations. Next slide, please. The requirements of the rule would not apply to individuals who enter into the sale of a business. However, and this is the definition in front of you, but however, the limit, I guess, if you want to call it that, or the exception with regard to the sale of a business only applies to a person who sells more than 25% of a business. So for example, if you were purchasing a business from, let's say, a family, a small business, or even a large business that's owned by a family, and let's say there's 7, 8 shareholders and they each have a little over 10% ownership, under the proposal, anyone having less than 25% interest in a business that's being sold could not be subject to a non-compete. Obviously, there would be a number of issues with that with regard to the practical effects of that. How and why would someone purchase a business from someone if they couldn't have a non-compete? Take the example, you sell a hot dog stand. The hot dog stand is owned by a family. The purchasing folks, they buy it, they pay all this money for the hot dog stand. The family, each person sells, let's say, their 10, 15% interest in the hot dog stand. The deal closes. The new owner is operating their hot dog stand. They're slinging fries. They're making their dogs. And then the family turns around and they go and open up a hot dog stand right next door or a block away. And it's not, and even though there was a non-compete, that non-compete, according to the proposal, would not be a proper non-compete because it's less than 25%, the individuals that sold it. The next slide, please. The rule also would take current non-complete clauses with workers and would, within a 180-day period from the rule being enacted, would require employers to notify employees that any non-competes that they're subject to are rescinded, that they're not applicable, they're not enforceable, and you can just imagine the issues with that. You take the current state of non-competes. You could have someone who left a business, maybe they turned in their equity or they sold their equity, there was a non-compete given. Maybe it's a situation, there was a severance, some package as part of someone that left a business. Again, maybe there was a purchase of a business. And you need to tell those employees that their non-competes are no longer good and that they're rescinded. And that would occur within the notice would occur within the 45 days, the first 45 days, but there's a 180-day period for compliance with this. You can imagine situations where there's pending litigation and there's a non-compete that's part of that pending litigation. What happens in that situation? You can imagine a situation where some executive left and they're on some kind of payout and they're under a non-compete and the business owes the money to the executive, but there's a non-compete, but the non-compete is no longer valid. It has to be rescinded. Next slide, please. So you can imagine the things that happen in those situations. The proposed rule would specifically supersede all state law. And so, for example, we have 50 states. We have 11 of them that have what we call low-wage worker statutes, where non-compete provisions are permissible for certain workers over a certain dollar amount and not for others under a certain dollar amount. That would be superseded. We have approximately 30, I'll just say 37 or so states that have permit non-competes outright. And in those states, that would all be superseded. So you can imagine the issues that would occur with that. For example, there's Supreme Court issues with an agency overstepping its authority. Recently, in 2022, the Supreme Court declared in West Virginia versus EPA that the EPA didn't have authority to impose a certain environmental regulation under what's called the major questions doctrine. There are other cases, a couple other cases that deal with that same issue. This is likely subject to the same scrutiny with regard to that case, because the FTC, the argument is that under Section 5, they don't have authority to do this. There's also a non-delegation doctrine potential violation that Congress didn't delegate the FTC to regulate in this area, and yet it did. Next slide, please. And why is the FTC doing this? Well, you may recall there was some talk about a white paper in the Obama White House. The paper went around and was essentially questioning the applicability or use of non-competes. President Biden, in his campaigning, said he wanted to take a shot at non-compete agreements. The FTC, a day prior to releasing this rule proposal, they announced 3 enforcement actions against essentially hourly wage workers in the security industry and in the manufacturing of food containers, glass in particular, industry. And then this came out. There's an op-ed piece done by the chair of the FTC. So a lot of orchestration around this, and their justification, as you can see on the screen in front of you, is they want to conclude that non-competes hurt workers, it reduces wages, it stifles new business, exploits workers, and there's other ways to protect trade secrets and other valuable investments. And the FTC has built an expertise of non-competes through years of policy analysis and public engagement. Well, they've done nothing in the last 100 years, as pointed out by, I believe, by Commissioner Wilson in a dissent with regard to this rule. The FTC has no experience in this issue, and yet they claim to have experience. So that's the justification. So what's been the response? Let's talk about the responses to the proposed rule. Sean Heather, U.S. Chamber of Commerce, next slide, basically said, since the agency's creation over 100 years, Congress has never delegated to the FTC the authority to regulate or promulgate rules in this area. So you can imagine the challenges that will take place for legal reasons. There's also other reasons why there's a problem with this rule. Let's go to the next. There you go. As I mentioned, Commissioner Wilson dissented on the rule and said what's in front of you, that this is a radical departure from hundreds of years of legal precedent that requires a fact-specific inquiry into these things. The commission undertakes this radical departure despite what appears to be a lack of clear evidence to support the proposed rule. I mean, for example, there are serious concerns. Why would businesses invest in innovation? Why would they invest in research and development? Why would they invest in training? Why would they invest in employees if they can't protect their workforce, protect their clients, protect their innovations, their intellectual capital? If you can't protect those things, why would businesses invest if someone could just take those things and go to a competitor? The FTC also says, well, there's rules with regard to trade secret and other intellectual property infringement. But for example, in the trade secret area, one of the requirements with regard to trade secret enforcement issues or misappropriation is to actually show that you took reasonable measures to protect the secrecy of the information you're trying to protect. And how do you do that? Well, one of the ways to do that is with non-disclosure agreements, with non-compete agreements, and those sorts of things. And yet, in the proposal, you can't use a non-compete agreement. And then they even question non-disclosure agreements. And it seems to be that there's not enough practical research and understanding of the business world with regard to the rule being promulgated here as to how businesses develop and innovate. And then they want to take the investment they made in that innovation and they want to monetize it. In order to do that, you need to make sure that someone can't just walk away and use that information, that someone can't simply walk away, go to a competitor and go and develop the exact same thing that they just worked on for you. It also hurts other employees at that same business because there's other employees who maybe they're engaged in profit sharing. Maybe they have a form of equity that's affected by the success of the company, by its profits. Maybe their bonus is affected. And all those things are put into doubt if you can't protect these things. And yet there's no discussion of that in the proposed rule. What happens next? Well, as we mentioned earlier, there's a comment period right now. And let's see, alternative approaches. Let's go to that slide, please. So what happens next? Well, there's a comment period, and the comment period is through March 20th currently. It could be extended. There's no way of knowing if that'll happen or not. And within the proposal, the FTC actually notes things that are actually being done in some of these low-wage worker state statutes where non-competes apply to a certain level of employee or a certain type of employee. And they're asking for comments on those things, which may signal that there may be some modification to this proposal depending on the comments. There may be no modification, or there'll be potentially court challenges, which there's a high likelihood based on current Supreme Court precedent that the FTC may have overstepped its bounds. But there's alternative approaches with regard to who these things might apply to, with regard to dollar limits and other proposals on the types of restrictions that you might be able to apply to different employees in different situations that are also in the proposal and for which people can also comment. Next slide, what happens next? As I mentioned, there's the comment period, and after the comment period, if it went into effect after the comment period, there's 180 days of a compliance period with regard to rescinding non-competes and moving forward. There's been thousands of comments already. I last looked just a few days ago, and there were approximately 4,000 comments. I suspect there'll be thousands of more comments. We know from our experience that there are clients and associations that are also preparing comments with regard to this. So you can expect a flurry of activity over the next month and a half with regard to this proposal. I think we turn this over now to the next section, notable restricted covenant cases. Robert, I think you're up.
Thank you, Michael. At this point, what we'd like to do is highlight some of the notable restrictive covenant cases that came up in 2022. I think what's important to note is that in 47 states, non-compete agreements continue to be enforceable with employees. And so the silent majority of what occurred in 2022 is the continued enforcement of non-competes. Now, certainly there are defenses to the enforcement of non-competes, particularly where there's not legitimate business interests and there's overbreadth. But I think what gets lost in this this sort of populist frenzy, what you're seeing in the media now as far as the proposed ban, is that there's a consciousness that employees feel that non-competes are no longer valid. And that's certainly not the case, and that's what we see from 2022 is that non-competes continue to be enforceable, non-solicitation agreements continue to be enforceable. What we'd like to do is highlight a few key cases that came up in 2022 as far as low-hanging fruit, as things you need to know. And we'll go to that slide, please. There was two significant cases from the Supreme Courts in Hawaii and Wyoming. First off, a significant case in Hawaii having to do with real estate brokers. A brokerage firm brought an action against a former real estate broker claiming that the broker violated a non-compete agreement by establishing his own business and soliciting brokerage firms' agents. Ultimately, the Supreme Court granted certiorari and took a look at the non-compete issues. And what the Hawaii Supreme Court held was that the non-compete clause at issue was not ancillary to the protection of non-trade secret business information, and that it evidenced a desire to prevent the broker from competing a competing firm, and that was not a legitimate purpose for the non-compete. So the key thing there is that non-competes remain enforceable in Hawaii, but you need to have a legitimate business interest, such as the protection of trade secret and confidential business information. It's an example of what, over the course of the country, that non-competes are used to protect legitimate business interests, such as trade secrets. And that was evident in the Hawaii Supreme Court's decision. And what the court also held is that the mere termination of the agent's employment with the brokerage firm did not demonstrate a violation of the non-solicitation clause. And the Hawaii Supreme Court defines solicitation under Hawaiian law, and that solicitation for the purposes of a non-solicitation clause in an employment agreement requires the active initiation of contact. And so based upon the court's reasoning, the the court found that the case needed to be returned to the trial court because there was a genuine issue of material fact regarding the broker's initiation of contact with the coworker that precluded summary judgment for the brokerage firm. The next significant case came out of the Supreme Court of Wyoming, dealing with the blue pencil rule. In this particular case, the employer sued the former employee for breach of the party's non-compete agreement. The trial court entered summary judgment for the employer after using the blue pencil rule to modify some of the restrictions in the non-compete agreement to make them more reasonable. The employee appealed. The Wyoming Supreme Court held that the courts may not exceed the scope of their traditional authority in contract interpretation by using the blue pencil rule to modify restrictions in non-compete agreements to bring them to make them more reasonable. And in this particular case, the Supreme Court was dealing with some contrary authority, but they made it clear that this particular jurisdiction, that they were not going to blue pencil overly broad non-compete agreements, and found that the particular non-compete agreement was unreasonable on its face and therefore void in violation of public policy. The next significant case came out of California, and this is in the context of a buy-sell non-compete, as opposed to just a plain naked employee non-compete. It was the non-compete at issue was in the context of the buy-sell of a business. And in this particular case, Blue Mountain, the California Court of Appeal found that Business and Professions Code Section 16601 applied to a 3-year post-termination non-solicitation of customer provision in the employment agreement. And the Court of Appeal upheld the trial court's decision to enforce that provision against the executive seller who had entered into a joint venture arrangement. The court found that the Section 16601 applied as a matter of law because the defendant disposed of all of his ownership interests in one transaction agreement while concurrently agreeing under an employment agreement, and that both contracts, along with other contracts that the parties executed, were drafted to accomplish the parties' joint venture. The court also found that the trial court correctly found that the defendant's letter for his new business constituted a solicitation as a matter of law because the letter went well beyond an announcement by actively encouraging customers to leave and do business with his new company. And lastly, the court affirmed a rather large trial court award of attorney's fees for having to enforce the non-solicitation provision. Another significant case that came up last year was in Delaware, and the upshot on this particular decision is that you need to be very careful in drafting your non-competes in the buy-sell context in Delaware, because the court there is not always going to blue pencil an overly broad covenant. This particular decision, Kodiak Building Partners versus Adams, came out in October of 2022. And the vice chancellor ruled that the restrictive covenants imposed on a stockholder in an acquisition were overly broad and unenforceable. And the court decided to decline to apply its blue pencil to reform the overly broad restrictive covenants on the basis that to do so would be inequitable. In this particular non-compete situation, the particular business that was at issue had one location and in one general geographical location. What the non-compete did is that it extended to 81 locations, and it expanded to more than the actual line of business that was sold. And so there the court was very reluctant and decided not to blue pencil the particular agreement because the restrictive covenants were overly broad and unreasonable, and the vice chancellor felt that there was an inherent inequities in blue penciling the non-compete. And so this was an eye-opener to a lot of folks, particularly those that do business transactions, because there was a lot of flexibility, believed flexibility in the blue pencil doctrine, that if you drafted something that was that turned out to be overly broad, that the court would reform it to make it more reasonable. But in this particular instance, the court said that the actual non-compete went well too far from a legitimate business interest. It's interesting to note that even though the actual agreement was found to be overly broad, it was undisputed that the particular employee was actually violating the agreement with respect to the mile restriction and with respect to the same type of business. So it was just that it was theoretically overly broad, but in practice, it was undisputed that there was actually a violation. Lastly, we had a significant decision in the Fifth Circuit having to do with Louisiana non-competes. And in this particular decision, the Fifth Circuit upheld the federal court in Louisiana's decision that the non-compete was unenforceable against the employee because the employee had signed the non-compete when he was not actually an employee. Obviously, the facts matter here. In this particular instance, he was merely an applicant who was later offered employment and accepted a job. And so it really teaches that you need to make sure you have a good process in place when you're presenting the non-compete agreement to the employee, and obviously be mindful of those state laws that require you to present the non-compete, before employment. In this particular case, there was a phone interview in December. They sent the non-compete agreement, and the employee signed the non-compete agreement in December. However, the offer of employment didn't come in until January, and the employee didn't begin his employment until February. And this was enough for the Fifth Circuit to hold that that the non-compete that the non-compete was valid under the Louisiana non-compete statute because he was not an employee at the time that he signed the non-compete. With that, I will turn the presentation over to Josh Salinas, where we saw a lot of action outside of the case law. We saw a tremendous amount of action on state legislatures passing laws that regulate restrictive covenants.
Thanks, Robert. On the next slide, we have a brief overview of what we've seen this past year with the changes in laws regarding restrictive covenants, both on the state and federal level. We've seen over 60 state bills related to restrictive covenants just this past year that were pending. And we continue to see significant changes with more and more states either implementing new restrictions, new notice requirements, having different income thresholds, or making changes to their existing laws. I think the significance and takeaway is that there's some greater challenges now for multi-state employers. We've seen choice of law, venue challenges, increased penalties for noncompliance, this increased focus on compensation and duty thresholds for restrictive covenants. And it appears that it's becoming more and more difficult to have this one-size-fits-all approach with agreements and policies. And I think one additional takeaway to see with all these changes is now in the context of companies having maybe a more remote workforce with employees maybe working in new states, companies employing people who they may have not employed before in those states. Now there's some considerations to make sure that those agreements and policies regarding employee mobility do comply with these new changes in the law. Next slide. So one state we did see make some changes was Colorado. Effective August 10th, 2022, it had a new law that provides any covenant not to compete that restricts the right of any person to receive compensation for labor for any employer is void. But there are certain limited exceptions. We have a chart on the slide that shows some of the distinguishing income thresholds for non-competes versus customer non-solicitation agreements. And similar to a number of other states, these laws or these income thresholds gradually increase over each year. One of the key takeaways is this term of the annualized cash compensation. What this means is the amount of the gross salary or wage amount, the fee amount, or any other compensation for a full year that person earned when they were employed or engaged. But it can also mean for employees who don't work a full year, the compensation that person would have earned based on their gross salary or wage amount, fee, or other compensation if they had not been employed or engaged for a full year. Now, there's some requirements for enforcement. It must be for the protection of trade secrets, and it cannot be broader than reasonably necessary to protect the employer's legitimate interests in protecting the trade secrets. The employee must earn this threshold of the annualized cash compensation that we have listed. But the employer must also disclose the terms of the covenant to the prospective worker before they accept the offer of employment, or to any current worker at least 14 days before either the effective date of the covenant or the effective date of any additional compensation or change in the terms of conditions of employment that provide the consideration for the underlying covenant. Now, there are some additional notice requirements. The employer must provide notice in a separate document apart from the underlying covenant between the worker and the employer that has clear and conspicuous terms in the language in which the worker and employer communicate about the worker's performance. This notice must be signed by the worker, and the employer can satisfy this notice requirement when the notice provides the employee with a copy of the agreement containing the non-compete, identifies the agreement by name, and states that the agreement has a non-compete that could restrict the worker's employment mobility options following separation. And then it also directs the worker to the specific sections or paragraphs of the agreement that contain the non-compete. One new development that Colorado has followed some other states who have changed their laws is that it actually bans non-Colorado choice of law and form selection provisions. And the specific language provides that a covenant not to compete that applies to a worker who at the time of termination of employment primarily resided or worked in Colorado may not require the worker to adjudicate the enforceability of that covenant outside of Colorado. But notwithstanding anything to the contrary, Colorado law does govern the enforceability of a covenant not to compete for a worker who at the time of the termination primarily resided and worked in Colorado. Now there's some penalties for noncompliance, which include actual damages, a penalty of $5,000 per worker or prospective worker harmed by the conduct. But then additionally, the statute authorizes a recovery of reasonable costs or attorney's fees for the grieved workers in addition to those actual damages. Next slide. For the District of Columbia, there was also a new law this past October 2022 that has restrictions on non-competes, but there are some limited exceptions. The language prohibits an employer from requesting that a covered employee sign an agreement or comply with a workplace policy that includes a non-compete. Now, the limited exceptions are for covered employees, which includes DC residents and employees and prospective employees who spend or are reasonably expected to spend more than 50% of their time working in DC. Now, for what this non-compete provision actually means is it's a provision and agreement that prohibits an employee from working for another for pay or from operating the employee's business. And I think one thing to note is it applies not only to written agreements, but also workplace policies. Now, there are some exceptions. There is a sale of business exception for agreements between buyers and sellers of a business. And then also agreements that prohibit or restrict employees from disclosing, using, selling, or accessing confidential or proprietary information of the employer. There's also an exception for agreements that restrict the employee from accepting money or a thing of value for performing work for another person while they're still employed with that current employer because the employer reasonably believes that the acceptance of that money or thing under those circumstances would result in the disclosure of the employer's confidential or trade secret information, a conflict with some either the industry, profession, or the employer's established rules for a conflict of interest. There may be a conflict of commitment if the employee is employed by a higher education institution, or if there would otherwise be an impairment for the employer's ability to comply with the district's or federal laws or regulations, contracts, grants, or agreements. And then also an agreement that provides a long-term incentive would be excluded. Now, there is an exception for highly compensated employees, and what that means is essentially an employee who is reasonably expected to earn from the employer in a consecutive 12-month period compensation that is greater than or equal to the minimum qualifying annual compensation, or somebody whose compensation earned from that employer in the consecutive 12 months preceding the date in which the proposed term of the non-compete is to begin is greater than or equal to the minimum qualifying annual compensation. Now that qualifying compensation we have listed, it's higher for medical specialist, which is $250,000, or $150,000 for all other employees. And similar to other states' laws, this threshold is planned to increase next year. Now, one carve out for highly compensated employees is it does not include broadcast employees. And so those are individuals who are on or off airs, such as anchors, disc jockeys, editors, producers, reporters, or writers. And that's for an entity that owns or operates one or more of the following, either TV stations or networks, radio stations or networks, cable stations or networks, satellite services that are similar to those broadcasting stations or networks, or any other entity that provides broadcasting services such as news, weather, traffic, sports, or entertainment programming. Now, there are some additional notice requirements. The employer with a workplace policy that includes one or more of the exceptions to this definition of non-compete needs to provide a written copy of the provision to the employee, either 30 days after the employee's acceptance of employment with the employer, but also within 30 days after October 1st, 2022, which was the enactment of the new statute. And then also anytime this policy or anytime the workplace policy changes. And for a highly compensated employee, the employer needs to provide notice to the employee whenever a non-compete provision is proposed to the employee. The district's ban on non-compete, they need to provide the following disclaimer that the district's ban on non-compete agreements, Amendment Act of 2020, limits the use of non-compete agreements, and it allows employers to request non-compete agreements from highly compensated employees, as that term is defined in the ban on non-compete agreements, Amendment Act of 2022, under certain conditions. And then the employer must identify that they have determined that this employee is a highly compensated employee, and for more information about the ban, they can contact the DC Department of Education Services. Now, sort of additional penalties for non-compliance. I think one of the things to highlight is that there's different penalties for if the employer requires or requests that the employee sign an agreement, which is $500 to $1,000, and not less than $3,000 for subsequent violations. But then there's higher penalties if instead of asking the employee to sign the agreement, the employer actually attempts to enforce an unenforceable or void non-compete, and that's $1,500 up to $3,000. And then also the penalties for if the employer retaliates against the employee for refusing to agree to a prohibited non-compete or failing to comply with a prohibited non-compete, or if they're asking or informing or complaining about the existence, applicability, or validity. Those retaliation penalties are $1,000 up to $2,500, and not less than $3,000 for subsequent violations. Next slide. And Mike's going to cover the Illinois new law changes.
Thanks, Josh. And I'll make this quick because we want to make sure we get through everything. Effective January 1st, 2022, Illinois passed a new non-compete statute. We could affectionately call it low-wage worker statute. They set particular limits for non-competes and non-solicits with regard to who they can apply to. You'll see the chart in front of you, and you'll see it's progressive. It continues to go up, every 5 years. You can also see how earnings are defined, which is salary, bonuses, commissions, and any amounts there are deferred by employee, like a 401k plan. This is codification of the five-field rule. The five-field rule essentially says someone has to work in a position in Illinois who's subject to a non-compete for at least 2 years for the non-compete to be enforceable, unless, of course, there's other consideration that's given or additional professional financial benefits. That could be a signing bonus. It could be training. It could be other things. It's not specifically laid out. There are notice requirements on the statute, 14 days that needs to be given. So employers should think about how they take care of the 14 days, such as maybe with an employment application or certainly an offer letter, but you want to make sure it's 14 days notice before someone signs an agreement. And it also has to state that a person has a right to counsel to speak to them about the agreement that they're being asked to sign. The statute also contains a fee shifting provision that basically says if an employee if an employer brings a lawsuit against an employee and the employee prevails, the employee can get their fees and costs back. And then it also has a codification of reformation in the statute, where it essentially says that judges aren't supposed to rewrite an entire agreement, but it does confirm that the judge has the right to reform certain provisions of a non-compete or non-solicit to make them enforceable. And it identifies factors such as fairness and good faith efforts to have a proper restriction for legitimate business interests, and the extent of the reformation that is being provided for, and that you're supposed to have a clause that actually says that a court can do this if there's questions. Next slide. I think Josh, you're up, I believe.
Yes, Oregon did have some existing existing restrictions for restrictive covenant laws, but with this last year, we just wanted to highlight a few key points for some new changes. One is that the duration of non-competes has now been reduced from 18 down to 12 months for enforceability. There's new compensation thresholds. There's some change to the language for non-compliant agreements in that they're now deemed void instead of just voidable. And then also there's a notice requirement in which the employee needs to receive a copy of the agreement with the non-compete 30 days after termination, or the agreement becomes void. Next, so we have some new states that have enacted some new laws regarding non-disclosure provisions. California and Washington last year enacted the Silence No More Act. For California, there's some restrictions for non-disclosure agreements or non-disparagement provisions in employment agreements, and essentially it has a requirement that there needs to be language to the effect of nothing in the agreement prevents that employee from disclosing or discussing information about unlawful acts in the workplace, such as harassment or discrimination or other conduct they have reason to believe is unlawful. Washington had enacted a similar new law, and what that does is it prohibits employers from entering into enforcing a provision of any agreement that prohibits the discussion or disclosure of conduct that the individual employee reasonably believes to be illegal discrimination, illegal harassment, illegal retaliation, a wage and hour violation, or sexual harassment, or if the conduct is recognized as being against a clear mandate of public policy, or the existence of a settlement involving any of the previously mentioned conduct. And so going forward, next slide, looking into 2023, we've seen a number of states that are enacting these new income compensation thresholds or increasing their prior thresholds, and it's something we're going to continue to monitor. Next slide. And then there's 3 states that we've been closely following and will continue to monitor. The first is New Jersey. That's going to have some additional restrictions for their restrictive covenants, and it would essentially ban no poach agreements. Next state is Connecticut. Next slide. And we're going to be watching that. Similar, it has some additional restriction periods, and employers would also need to provide a copy for the employee. Next slide. And then lastly is New York. this would essentially prohibit employers from seeking, requiring, or demanding or accepting non-compete and avoid all contracts restraining the covered employees. Next slide. And with that, I'll turn it over to Robert.
Thanks, Josh. I would like to highlight now some of the significant trade secret cases and a new law that was recently signed by President Biden. Next slide, please. From a big picture perspective, in 2022, we continued to see large jury verdict awards. We saw a astronomical jury award in Fairfax County, Virginia for $2 billion. It was Appian versus Pega Systems. In this particular case, it was a jury verdict in May of 2022, and the allegations are that Pegasus Systems hired an employee from one of Appian's contractors, and as a part of the alleged scheme, the employee took with him Appian's confidential software program and documentation. The jury in this particular case awarded more than $2 billion in damages against Pegasus System, as well as against the employee. For $5,000, the jury found that Pegasus Systems acted willfully and maliciously with respect to the trade secret claim, and awarded over $23 million in fees and costs. Not surprisingly, Pegasus System is appealing the jury verdict, and I'm sure we'll see more activity in this case in 2023. There was also a significant jury verdict coming out of Ohio, $65 million jury verdict for the misappropriation of trade secrets regarding self-inflating tires. And I think if you step back, these particular cases, you're seeing vendors, competitors, and former employees who are involved in these alleged misappropriations. There was another significant case coming out of the Eastern District of Michigan against Ford, a $105 million jury verdict. In this particular case, the jury allocated $22 million for trade secret misappropriation and $82 million for breaching a licensing agreement for misusing confidential information. There was allegations that there was reverse engineering of the software at issue and the continuing use of the software, and a refusal to allow inspection and audit rights. So again, we expect to see, appeals in these particular large jury verdicts, but it's certainly an appeal. In these trade secret cases, often you're looking for an injunction, and we're seeing more of a focus on an attempt to get a large jury result. Next slide, please. As far as some general categories on misappropriation claims, there were some significant cases on the topic of misappropriation, as well as compilation trade secrets. There's a case that came out of California. Oftentimes in misappropriation cases, misappropriation is shown by circumstantial evidence. It's always, it's not always, easy, to get direct admissions. And so you have to cobble together your claim through circumstantial evidence. And in this particular case, the court pointed to the hiring of over 60 employees of a competitor, and that one of the particular employees had downloaded some of the source code, and that particular result was affirmed by the Ninth Circuit. And what the court pointed to was a plethora of circumstantial evidence indicating that there had been copied source code for the video game, that there were 60 of the 82 employees credited working on the video game at issue were former employees of the aggrieved party. One of those particular employees was given access to confirm the downloading of the source code, and that there was also preliminary analysis showing significant similarities in the existing code. But I think the significance is of the sheer mass hiring and rating of the workforce that the court pointed to as some evidence of circumstantial evidence of misappropriation. Another issue that comes up in trade secret cases is when you have a combination of maybe publicly available information that's mixed in with trade secret or information, and how that particular information is organized, And when there's a bit of public information, a bit of secret information, or just the organization of the public information being recognized as a trade secret. And we saw two cases, different results. In the Bimbo Bakeries case, the 10th Circuit found that no reasonable jury could find that the much broader compilation of a bread recipe that was claimed as a trade secret couldn't qualify as a trade secret. And in the particular decision, what the court pointed to was that the compilation of two ingredients and the production steps involved in the process of making a branded bread, that no particular jury could find that that was not generally known or readily ascertainable. The court noted that it's really just a matter of trial error and trying all four elements at all different levels. So in that particular result, the alleged compilation trade secret failed. In contrast, in the Sixth Circuit, a combination trade secret succeeded. In this particular case, the Sixth Circuit affirmed a $7 million win on a combination trade secret claim, finding that the plaintiff had shown that the research and development related to broccoli seeds was a combination trade secret. And there was also allegations that the defendant had poached a key executive to steal those secrets. In its decision, the Sixth Circuit explained that the plaintiff had repeatedly demonstrated that it had assembled a unique combination of processes and information that aided its research and development processes at a level of depth beyond just merely listing technical concepts. And so that's what we're seeing is more combination type trade secret claims where there's an insertion of public information or the combination of public information and secret information. Next slide, please. The damages, obviously significant in 2022. We're seeing more, damages cases. Those are often go up on appeal, typically because there's a large award or an aggrieved party that is looking for recourse in the appellate court. In the Codhill case that I mentioned, where there was the $7 million award, the Sixth Circuit upheld the jury's award of research and development costs as compensatory damages. There was also a significant decision in the Third Circuit on avoided costs. In this particular case, the defendant was alleged to have engaged in an obvious deliberate theft of trade secrets, but it argued that it hadn't benefited because it never actually manufactured a relevant product. The Third Circuit rejected that theory and explained that the secrets had been used to avoid extensive research and development and enabled immediate preparations for manufacture. And the court then held that it was appropriate to use evidence of the plaintiff's cost to develop the information as a proxy for the benefit that the defendant derived from the misappropriation, even though it wasn't able to carry out on its plan. So that's often a theory that defendants try to say, is that they never actually sold a good, but it's clear under the law that that's not going to be a viable defense to defeat damages being awarded. We also saw some cases as far as reasonable royalties. Oftentimes you look at the defendant's unjust enrichment. And what they would have been willing to pay in a hypothetical negotiation for access to that particular information. And in the Airfax case, the Fourth Circuit reversed a trial court ruling that the plaintiff could not recover royalty damages because there was no alleged proof that the defendant had ultimately used the trade secrets in commerce. What the Fourth Circuit pointed out is the focus on use is not the dispositive analysis. It's under the UTSA at issue in that case. Royalties can be appropriate for the unauthorized disclosure or use. And so in this particular case, the court concluded that it was not possible to condition such awards on putting defendants conditioning such awards on a defendant putting a trade secret to commercial use. In other words, just the mere disclosure of the trade secret was a justification for the recovery of royalty damages. And then we also had a significant case that came out of Texas, a pretty interesting case in dealing with recruiters and allegations that resumes could result in a trade secret claim. But in that particular case, the plaintiff was successful, and the issue on appeal was whether the $3 million trade secret damages was appropriate. And what was argued to the jury is that the damages were based upon the value that a reasonably prudent investor would have paid for the trade secret. And the plaintiff argued that this metric was appropriate and a bedrock damages measure in trade secret cases. The defendant contended that the trade secret's value was only recoverable if that value was destroyed by the misappropriation. The Fifth Circuit rejected the defendant's argument and indicated that that they agreed with the plaintiff that the complete destruction of the trade secret value is not necessary under the reasonably prudent investor measure of damages, and cited to a number of cases in the Fifth Circuit as well as Texas law that it's the usually accepted approach that where their secret has not been destroyed and where the plaintiff is unable to prove a specific injury, that it's appropriate to use the value a reasonably prudent investor would have paid for the trade secret. So some real interesting damages decisions this year. Next slide, please. Reasonable secrecy measures are often, challenged, and I think the main key there is the more that you actually have an agreement as opposed to the policy or some sort of an oral arrangement, the better stead you're going to be in, and that was shown in two significant cases this past year. There's the Turret Labs case. In that particular case, the plaintiff had surrendered control of the algorithms to a customer. And one of the competitors of the plaintiff had obtained the information from that third-party customer, and under the agreement between the plaintiff and the customer had access to use the alleged algorithms as they wanted to, and so the court pointed to that as being dispositive that there weren't reasonable secrecy measures, since the third party customer had ultimate control about how to use the alleged trade secret. Another significant case was the Altman Stage Lighting case in New York, and on this particular case, the court granted a motion to dismiss because the only thing that they could show for reasonable secrecy measures were alleged oral instructions, and the actual complaint was silent as to any confidentiality agreements or written security policies. Another case we continue to see is preemption. And this particular case came out of California, but the court in California allowed the non-trade secret claims to survive and found that they were not superseded by the trade secret statute. The particular claims at issue were breach of duty of loyalty and unlawful interference with prospective economic advantage and statutory unfair competition. The California District Court found that the alleged unlawful statements made to divert business to customers were not preempted by the trade secret statute. The plaintiff had premised those claims, those non-trade secret claims, that the defendants engaged in wrongful conduct to divert business to the plaintiff's competitor, and that they also solicited employees while they were still employed by the plaintiff. And the court found that those allegations stood as independent claims and were not therefore superseded by the California trade secret statute. Also, we oftentimes see challenges of the underlying complaint, probably more so at the federal level if they're bringing a DTSA claim, trying to use Iqbal or Twombly to challenge the trade secret complaint. And as you saw in the Altman stage case, that particular motion to dismiss was successful, but we did see a different result in a significant case in California. In the Zimmer decision, the California District Court rejected the motion to dismiss, finding that the allegations of trade secret misappropriation were sufficient. In that particular complaint, there was an identification of 13 general trade secrets, along with explanations as to why those were trade secrets. The court rejected the defendant's challenges that the pleading was insufficient. They found that the plaintiff had alleged how it had gained access to the trade secrets and how it had used the information. And it also rejected the defendant's contention that the trade secret claim sounded in fraud and therefore was subject to Rule 9 of the Federal Rule of Civil Procedure's heightened pleading requirement. So that was another significant case. Next slide, please. And then lastly, something that's kind of flown under the radar is that there was actually our Congress actually did pass an intellectual property law, and it was signed into law in 2023, and it's called the Protecting American Intellectual Property Act of 2012. And this is actually a law that's focused on protecting American businesses from trade secret theft. I think there's a real focus on China, but the law requires the president to report annually to Congress foreign entities and individuals who engage in trade secret theft that pose a threat to the U.S. economy or national security, and that the law requires the president to sanction those entities and individuals. And there's a number of different sanctions that are available to the president under existing law, and some of those can be quite firm and sweeping, such as export prohibitions and prohibitions of loans from U.S. and international financial institutions. For any individual that's identified in the report to Congress, the president must impose property blocking sanctions and prohibit the individual's entry into the United States. So this can be very significant, particularly if US-based companies are doing business as either joint venture partners or licensees with any of these companies that may end up on the president's list. We will be doing a blog entry on this particular new law, but it actually is quite significant, and it's kind of flown under the radar with all the noise that we're hearing about the FTC non-compete law. With that, I'll turn it over to Josh, who will follow up with our last remaining items.
Thanks, Robert. And before we move on, I'd like to provide the CLE code, which is going to be required on the CLE verification form that should be emailed to you within the days following the webinar. So the CLE code is SS7643. That's SS as in Seyfarth Shaw, 7643. So SS as in Seyfarth Shaw, 7643. Now, to just wrap up in the interest of time, I'm going to cover two last points. One is the increased government activities, and then lastly, the latest developments in the CFAA and computer fraud. So next slide. So we have seen some increased government activities. As Robert just mentioned, we saw the Protecting American Intellectual Property Act of 2020, but we also saw Biden's executive order promoting competition in the American economy. And this executive order was to encourage the FTC to consider exercising its statutory rulemaking authority to curtail the unfair use of non-competes and other clauses or agreements that may unfairly limit worker mobility. And so this directive does not have any immediate legal impact on restrictive covenant enforcement, but this was framed in the terms of curtailing what the Biden administration viewed was abusive practices regarding the use of non-competes. We saw the DOJ had their first criminal antitrust indictment for no poaching agreements between employers, and I believe they may have secured the first guilty plea towards the end of last year. And then the FTC, we just saw recently, just only several weeks ago, three actions brought against companies and I believe 2 executives for imposing non-compete restrictions on employees. And so it's something we're going to closely monitor regarding the increased FTC scrutiny enforcement actions. Next slide. And then just briefly, we saw some federal bills that we're going to be watching regarding the restrictive covenants kind of going into next year. Next slide. And then last, we just wanted to cover computer fraud after Van Buren. Next slide. And so It was a long-awaited decision which the Supreme Court had resolved a circuit split about whether an individual with access to a computer system violated the Computer Fraud and Abuse Act by accessing information for an improper purpose. And we highlighted at last year's webinar that the Supreme Court held that an individual does not exceed authorized access under the CFAA by misusing access to obtain information that is otherwise available to that person. And that case was a criminal case involving former law enforcement officers' criminal conviction. That decision was expected to, and we've seen some broad ramifications for trade secrets and restrictive covenant litigation, as those computer fraud claims are often brought against employees who misuse their access rights to misappropriate information. And so we did see, in light of that Van Buren decision last year, the DOJ revised their policy for charging CFAA offenses. They took the new narrowed interpretation of exceeding authorized access. And we just saw some increased activity regarding computer fraud and ransomware, with federal prosecutors in Los Angeles and Alaska charging 6 defendants with operating websites that offered computer attack services. There was a notable case after the Ninth Circuit that essentially followed the reasoning in Van Buren, HiQ Labs versus LinkedIn. This was a case involving alleged data scraping of information on LinkedIn public profile websites. There was a previous decision in 2019 in which the Ninth Circuit had held that the public information did not violate the CFAA because it was publicly available. But following the Ninth Circuit's order, the Supreme Court issued the Van Buren decision. And then essentially it concluded that the individual who exceeds authorized access when they access a computer without authorization, but obtains that information in publicly available or available areas didn't violate the statute. And so just as a kind of procedural timing, the case in the HiQ Labs was remanded back to the Ninth Circuit after Van Buren, but the Ninth Circuit again reaffirmed the trial court's preliminary injunction and concluding that Van Buren essentially reinforced its earlier interpretation using that more narrowed interpretation of the statute. And so I think that the takeaway essentially is with the Ninth Circuit, it did apply and upheld this now more narrowed interpretation of authorization under the statute. But that does not necessarily mean that entities do not have any additional mechanisms to protect themselves. Even if the CFAA may not apply, there's still additional causes of action such as trespass of chattels, copyright infringement, misappropriation, unjust enrichment, conversion, breach of contract, breach of privacy, or other claims that may be potentially viable depending on the facts of the case and jurisdiction. And so with that, we thank you very much for your time. We have a 50-state desktop reference that we have updated for this year that includes all the latest developments and changes to the state restrictive covenant laws. And then also you can continue to monitor our blog, and we'll be having more webinars this year regarding the latest developments and trends in trade secrets, non-competes, and computer fraud law.